Dustin, good to see you. We have such an important topic today, protecting a child with disabilities through estate planning. Parents and grandparents often aspire to leave behind a legacy, and providing care for a child with special needs is especially important. But for children with disabilities, an inheritance can often come with problems. Can you explain?
Sure. So it's often very common for parents and grandparents to want to distribute their estate in equal shares to their kids.
Yeah.
Um, but if one of those children has disabilities or special needs, it can create a couple of big problems. One, they may not have the capacity to effectively manage those assets,
Hmm.
but also oftentimes those children, they might be relying on some kind of state benefits, SSI, Medicaid, something like that. And all of those systems tend to come with means tests. So they're going to look at the assets that that child or that person with disabilities owns in order to determine their qualifications. So oftentimes, if they receive an inheritance in their own name, it could mean losing those benefits that they rely on.
Right, that would be terrible. So that is a great action step. Let's talk through a few more to make sure your child is protected no matter what happens. And you say make sure that you have an up-to-date estate plan that reflects your wishes. And this may also include a special needs trust.
Right. It might mean a special needs trust, or it might simply mean including some special needs trust language
Okay.
inside any other trust, like a revocable living trust. And what that will allow for is, those parents or grandparents can still have their assets distributed outright to most of their children upon their passing if they wish. But what we usually do is make sure that the assets or the share that that child with special needs would receive remains in trust, and a successor trustee manages those assets for the benefit of that child or person with disabilities. And they can use those assets to provide for something we call HIMSS, that person's health, education, maintenance, and support. And that's a
Yeah.
really broad standard. It
Hmm.
means that, in a practical sense, that trustee can spend those funds in virtually any way that's needed for the benefit of that beneficiary. They can buy them a house, they can buy them a car, they can pay their monthly bills, and provide for travel. It's just a very, very broad standard. But because that child doesn't receive that inheritance in their own name, it prevents losing those benefits because of
Right.
a means test on their assets.
Hmm. Thinking about that, are there other beneficiaries who should not receive that inheritance outright?
There are a lot of cases where beneficiaries, you may not want them receiving an inheritance in their own name or receiving it outright. A few examples would be a minor child who can't legally control those assets, or you might have children who are technically adults, but they're still very young. And you might want your children to maybe work a little bit harder into their late 20s, or maybe their 30s, or maybe even age 40 before they receive a large inheritance. You might have someone who's what we would call a spendthrift, just not very good with money. You're afraid that if they receive that inheritance in their own name, that they're just going to burn through it and not receive any real benefit. That would be a case where there might be some benefit to have a trustee manage those assets and provide some guidance. Another example would be somebody with substance abuse problems. The last thing we'd want to see is somebody receiving an inheritance and only do harm by receiving that inheritance, harm to themselves.
Hmm. So, aside from protecting the beneficiaries, are there other reasons to include a trust in your estate plan?
Certainly, two big reasons come to mind. So, first, with a trust, it can be a very simple way to avoid probate, not only for one spouse but both spouses. What that means is the surviving spouse, they don't have to go through the hassle and the cost of probate. The kids don't have to go through that. It's a private transaction distributing that estate, and that inheritance, that estate can be distributed to the beneficiaries without the involvement of the court in any way, without the cost and the time of going through probate.
Hmm.
Another consideration would be if mom and dad place their assets in trust and mom and dad serve as the trustees of that trust. It's a very common arrangement where they're managing their own assets in trust. If one of them becomes incapacitated, let's say they get dementia, well, the remaining spouse continues to serve as a trustee. They continue to maintain full access and full control of all those assets. And they do that without having to go to the court and get a guardianship or a conservatorship, which again can be a very costly and timely process.
Mhm. And then, of course, a really important step as we talk about the trust too, you need to identify a caregiver, and this step should happen sooner rather than later.
Absolutely. And this is something that would apply whether we're talking about a child with disabilities or special needs or any other minor child.
Yeah.
You don't want your court making the decision who's going to provide care for your child, who's going to raise your child, or who's going to make medical decisions for your child when you can't do that. So
Mhm.
it's a reason for virtually anyone, a reason why they should have an estate plan in place. If they've got minor children, even if they've got little to no assets, you need a plan in place specifying
Mhm.
those wishes.
Mhm. And of course, whenever possible, try to involve the whole family. And because this is so important and so complicated, seek professional guidance.
Absolutely. So when we do estate planning, we're not just bringing in mom and dad and the attorney. We
Right.
also try to bring in the kids, the beneficiaries, and the successor trustees. So everyone understands, give them the chance to ask some questions. We do some successor trustee education. So everyone will understand when somebody becomes incapacitated or when somebody passes, what's going to happen and what they need to do, and also where they can go for help.
Mhm. And Dustin, you are such a great resource. Clearly, proactive planning is key. If somebody wants to talk through this issue, what's the best way to reach you?
They can text me a question at 830-476-2505 or reach out on the website to book a free chat at longlivemymoney.com.
Great. Dustin, thank you.
Thanks, Aaron.